Mr. Speaker, as the honourable move of the bill would have indicated, St. Kitts and Nevis has been in the process of seeking to fortify its compliance with international financial standards for quite some time. There are two main international institutions that have been involved in promulgating the requisite standards. The Financial Action Task Force, FATF for short, is one such body. It was initially formed in 1989 with the objective of targeting international financial crime in the form of money laundering. But after the events of September 11th, 2001 in New York, when the Twin Towers of the World Trade Center were attacked, it soon became the international watchdog for both money laundering and terrorist financing. And in that connection, it seeks to ensure a coordinated global response to prevent organized crime, corruption, and terrorism. This has since been expanded to include proliferation of weapons of mass destruction over the last couple of years. With a membership that numbers over 200 countries, the FATF has a mandate to assist authorities in going after the money of criminals, dealing in illegal drugs, human trafficking, and other crimes, and has developed the FATF recommendations or FATF standards, some 40 of them, which ensure a coordinated global response to prevent organized crime, corruption, and terrorism. The FATF reviews money laundering and terrorist financing techniques and continuously strengthens its standards to address new risks, such as the regulation of virtual assets, which have spread as cryptocurrencies gain popularity. Additionally, the FATF monitors countries to ensure they implement the FATF standards fully and effectively, and holds countries to account that do not comply. This is largely done through a process known as mutual evaluation, where member states assess and monitor the progress of other countries in adhering to the agreed upon international standards for global financial security. Mr. Speaker, the FATF has reviewed its standards in 1996, in 2001, in 2003, in 2012, and as recently as 2018 and 2019. And as part of the training afforded to its membership in preparation to evaluate and to be evaluated, members of the Financial Services Regulatory Departments, law enforcement personnel, and customs officials, who all form part of the front line for the Federation, would have been beneficiaries of training as mutual evaluation assessors here in St. Kitts and Nevis. And in a similar vein, Mr. Speaker, the membership of St. Kitts and Nevis with the OECD has also required us to comply with those particular standards. The OECD, as you recall, Mr. Speaker, is the Organization of Economic Cooperation and Development, and is an international organization that seeks to shape policies that foster prosperity, equality, opportunity, and well-being for all. One of the areas that it focuses on is that of tax compliance and reducing and eliminating harmful tax practices. I refer to the work of this body since both the FATF and the OECD often work in tandem and in a coordinated way to safeguard the soundness of international financial structures. As global trends and policies change, it is imperative for domestic policies to maintain a level of fluidity in order to keep in step with such changes. Mr. Speaker, we have seen in this age of the 21st century how knowledge and access to knowledge have continually seemed to surpass themselves as new developments have occurred at a lightning speed. With these developments, we have likewise witnessed how criminals have themselves become very flexible, adaptable, and have found ways to exploit financial systems and to unduly enrich themselves to the serious detriment and indeed destruction of others. At the core, therefore, of what organizations such as the FATF and the OECD and the anti-corruption body called MESISIC, that's a body within the OAS, of which we are also signatory, seek to promote, is that good governance, fair play, and respect for the rule of law are principles that should concern us all, whether we are seated in Washington, D.C., in Mozambique, or in Charlestown or Bastia. The Speaker, Mr. Speaker, as indicated by the honorable move of the bill, Senkis and Nevis is currently hosting the mutual evaluation team of the Caribbean Financial Action Task Force, CFATF. The process of preparation for this important assessment, Mr. Speaker, did not only just commence, but has been ongoing for quite some time. In 2018, the World Bank would have assisted the Federation in doing an overall assessment of its national money laundering and terrorist financing risks. This assessment would have produced a national risk assessment report, the key elements of which would have been disseminated to key stakeholders here in St. Kitts and Nevis, including the banking sector, law enforcement, and the designated non-finance business and professions sector, the DNFBP. In 2019, the process of preparation and strengthening of our anti-money laundering and counter-terrorist financing framework was solidified in a high-level commitment of establishing a national anti-money laundering committee, which is chaired by the Attorney General. The committee has a mandate that includes the following: issuing operational and informative guidelines on the mutual evaluation to all relevant agencies as necessary, engaging public and private stakeholders and conducting focus group discussions, meetings and workshops in preparation for the mutual evaluation of St. Kitts and Nevis, conducting risk-based outreach for sectors requiring enhanced focus, especially those agencies deemed to be high risk with respect to money laundering and terrorist financing, setting timelines for deliverables and to monitor the progress of submissions made by the relevant government agencies and private stakeholders, submitting or approving the submission of documents, reports, statistics, and case studies to the Mutual Evaluation Assessment Team as evidence of compliance, coordinate with supervisory authorities and other government agencies for the issuance and implementation of the necessary policies and regulations addressing the gaps identified in the anti-money laundering and counter-terrorist financing framework to ensure full compliance with FATF recommendations. And finally, to coordinate actions to assess the national money laundering and terrorist financing risks. Mr. Speaker, the chairmanship of the National Committee rests with the Attorney General with the Financial Secretary as Deputy Chair, and I can assure this Honourable House that all these tasks have been embarked upon and are still being worked upon as part of our process of preparation and deliverable. We have liaised and had several meetings with not only government representatives, but also relevant private agencies, including high-level representatives from the Banking Association, the Bar Association, and the Accounting Association. We have conducted mock evaluation interviews and facilitated information sharing on different levels as we have sought to enhance the dialogue in these areas. Since its official inception in or around October of 2019, the NAMLOC, or the National Anti-Money Laundering Committee, has met a number of times in its implementation of its subcommittees, which have also met on a more frequent basis. The committee is comprised of high-level representatives from relevant ministries and departments as follows: the Financial Secretary, the Commissioner of Police, the Controller of Customs, the Financial Intelligence Unit, the Controller of Inland Revenue, the Eastern Caribbean Central Bank, senior officials from both the Financial Services Departments of St. Kitts and Nevis, the Office of the Director of Public Prosecutions, the Immigration Department, and the Ministry of Justice and Legal Affairs. You may recall, Mr. Speaker, that this committee was given legislative backing when the National Assembly passed the Anti-Money Laundering National Committee Bill in January of last year. All of these actions, Mr. Speaker, demonstrate the seriousness and commitment with which the federal government has approached these matters that can have far-reaching efforts, both domestically and internationally. That should be far-reaching effects, both domestically and internationally. Mr. Speaker, I wanted to take some time to set the stage in relation to what informs the bills before this Honourable House today. Not just this one, but those others to follow, and to remind us of the foundational issues. I would want, Mr. Speaker, to having said that introductory portion, to turn my attention to the more salient points of the bill, as has been done by the Honourable Mover. But I should think that we should reinforce those. The bill currently before us, Mr. Speaker, the Miscellaneous Amendments Bill, is intended to address a number of small amendments in furtherance of the goal of greater legislative integrity as it pertains to our national security and financial services. The bill immediately seeks to amend the Financial Services Regulatory Commission Act, Mr. Speaker, the Tax Administration and Procedures Act, the Anti-Money Laundering National Committee Act, and the Anti-Terrorism Act. Mr. Speaker, when it comes to the Financial Services Regulatory Act, I should point out that the amendment seeks to clarify the definitions of what regulated person would be, regulated business activity, and regulated entity, while the other proposed changes of the Act are focused primarily on incorporating the element of financing of proliferation of the weapons of mass destruction. It should be pointed out, Mr. Speaker, that the Financial Services Regulatory Commission Act was first passed in this Honourable House in 2009 and came into force on the 26th of November 2009. And it had in its interpretation clause such terms as regulated entity, regulated service, the regulatory authority, regulatory functions. What we have tended to do in this miscellaneous bill is to clarify further what these specific definitions should be. Who is a regulated person? What is the regulated business activity? What is the regulated entity? When it comes to the Tax Administration and Procedures Act, Mr. Speaker, this provides clearly that the Controller of Inland Revenue is a competent authority in relation to tax crimes. Additionally, the legislation seeks to concretize the domestic coordination mechanism between the Controller and other relevant agencies. This was spoken to by the mover of the bill, because although we have one government, some of our agencies operate from time to time in silos, and there needs to be collaboration, cooperation among the different agencies. What this would lead to would be such activities as memorandums of understanding between agencies. There'll even be agreements to reduce to a very proper document the ways in which we collaborate to be able to advance our goal of preventing money laundering and terrorist financing. But when it comes to the question of the taxes and the Tax Administration Procedures Act, clearly this will have to lie with the Controller of Inland Revenue. The bill also seeks to reinforce the goals and the objects of the National Anti-Money Laundering Committee. What it does here is to introduce the question of the proliferation of weapons of mass destruction that had not been, at the time of the passage of the bill, had not been one of the objects of FATF. It has since been, and so we amend the bill to ensure that we have the legislative framework to deal with matters of the proliferation of weapons of mass destruction. Finally, Mr. Speaker, the bill will seek to amend the Anti-Terrorism Act to provide a specific fine in respect of offenses for inciting terrorism abroad. This, again, is a very important part of making ourselves technically compliant when it comes to the question of the mutual assessment that we are now undergoing. I just want to close, Mr. Speaker, by saying that the assessors have been here for the last 2 weeks, operating for the first 2 weeks, virtually interviewing a number of the agencies and stakeholders. And on Monday, from Monday of this week, they have been released from quarantine and are doing person-to-person, in-person interviews. It is critical that our country gets a good billing from this assessment, this mutual assessment. As the mover of the bill has said, the Honourable Prime Minister, the impact of us being able to be a proper member of the international community, to carry out our international obligations, require us to have proper procedures, the proper legal framework, which we would say allows us to have technical compliance, but also for our agencies to be able to show effectiveness in being able to operationalize those laws, that framework. And so we would hope that at the end of this process of mutual evaluation, that we get a clean billing here in St. Kitts and Nevis. And so we would want to have the support of the House in passing this piece of legislation and the others to follow, so that St. Kitts and Nevis can establish itself and show ourselves to be in good standing in relation to FATF recommendations, good standing in relation to our place in the global community, in the international community. May it please you, Mr. Speaker.